Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employer played a part in securing alternative employment for retrenched employees. May severance pay be withheld? Now, as you are aware, as a general rule, an employee dismissed for operational requirements is entitled to severance pay. This is codified in Section 41 of the Basic Conditions of Employment Act. However, an exception to this general rule is to be found in subsection 4. Section 41 subsection 4 provides that an employee who unreasonably refuses to accept the employer's offer of alternative employment with that employer or any other employer is not entitled to severance pay in terms of that subsection. So therefore, in accordance with Section 41, an employee who is retrenched is entitled to receive severance pay unless they have unreasonably refused an offer of alternative employment. Now, recently in Kanya Cleaning Group Pty Limited versus Satawu and others, the Labour Court clarified the extent of an employer's duty to make payment of severance pay in circumstances where the employer played an active role in securing alternative employment for the retrenched employees with a new employer. Now, we can all agree that when an employer finds alternative employment that is reasonable within the business, the issue regarding severance pay and the payment thereof is fairly simple. However, what if the employer secures alternative employment with another employer? Is severance still forfeited? Now, in terms of the facts of the case, the employer, Kanya Cleaning Group, is a contract cleaning services company which rendered services to a client. Its contract's validity period with the client came to its natural end and was extended on a month-to-month basis to allow the client's tender application process to be completed. The employer, Kanya, tendered for the new contract but was unsuccessful, and as a result of this, they embarked on a Section 189 retrenchment process. The bid was awarded to the employer's competitor, Supercare. The operations manager of the employer, Kanya, liaised between the affected employees and Supercare with the purpose of Supercare to offer alternative employment to the affected employees. The employer's MD met with the regional manager of Supercare in order to discuss the possibility of Supercare's offer of alternative employment to the affected employees. The employer shared all the affected employees' contact details with Supercare. The employer arranged for a venue for interviews to be conducted by Supercare, gave each of the affected employees paid time off in order to attend these interviews, and also provided them with application forms for employment with Supercare. The employer's argument was that it isn't obliged to make payment of severance pay to the employees as they were all offered alternative employment by Supercare through the employer's intervention. The union's argument, however, was that the employer played no more than a minor administrative role in Supercare's offer of alternative employment to the 30 affected employees, and therefore the union argued severance pay is due. A severance pay dispute was referred to the CCMA, and the CCMA found that the affected employees were entitled to severance pay because they had secured for themselves the alternative employment through no assistance of the employer. The employer approached the Labour Court to review the decision of the CCMA. Now, an argument before the Labour Court was that severance pay shall only be forfeited if there is a special term included in an agreement between the retrenching employer and the prospective employer, in terms of which the prospective employer will employ the affected employees. The court was not moved on this. It held that in order for a retrenching employer to escape the statutory obligation to pay severance pay, severance pay to the employees dismissed for operational requirements, it is not necessary to insist on the inclusion of a special term in an agreement with a prospective employer. The court held that there is a range of factors to consider when determining whether the retrenching employer is liable for severance pay. The evidence led by the employer was that the operations manager gave Supercare a list of its employees who were likely to be affected by this proposed retrenchment. Additionally, this ops manager put Supercare into contact with his MD for the purposes of Supercare meeting the affected employees. After this meeting, the ops manager booked a boardroom for Supercare to meet the affected employees. At this meeting, the affected employees were given employment application forms, and the meeting was scheduled during the employees' working time, for which their pay wasn't docked by it. The court held that it must be determined whether there has not only been collaboration between retrenching and acquiring employers, but also that the retrenching employer has been moved as a matter of some urgency into action to assist the acquiring employer with whatever information is required by it in order for it to offer alternative employment. Now, the court held that the CCMA erred in ignoring the evidence before it and instead focused too much on the fact that the employer had not concluded a special term in an agreement between it and Supercare. The court therefore concluded that the employees were not entitled to severance pay. Now, colleagues, in conclusion, the judgment confirms that in circumstances where an employer played a part in securing alternative employment for retrenched employees with a new employer and sought to be exempt from paying severance pay on this basis, it was not a requirement for it to have negotiated a special term with another employer to offer alternative employment to its retrenched employees. The focus should be on whether there has not only been collaboration between the former and new employer, but also that the former employer has been swift in assisting the new employer with the information necessary to enable alternative offers of employment to be made to the retrenched employees. That brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media or email me at vapia@massconsulting.co.za. Until next time, bye-bye.